I know that I have to give up the mic to my vice chair and good colleague, Representative Sorg, and I hope to be able to take questions later. Thank you.
Oh, boy. I don't know whether these glasses are going to do me any good or not. I'm getting to the point where my vision is so bad that whether I wear my bifocals or whether I wear my contact lenses aided by reading glasses, it still doesn't do me much good. So I bring notes here just as a security blanket, but really rather useless. The last time I spoke before a group of colleges, it was at Plymouth State College exactly a month ago today. It was in connection with Constitution Day, which was a week late. And it was in one of those big, giant lecture halls, and there may be 70, 80 people in there. And I kind of pictured that's what this would be. But this is not bad at all, because when I went there, I was picturing us being in like a hockey arena full of like 20,000 people. I don't know why I had that thought, because maybe it was because the conventions had just passed and I was used to seeing people present in that way. But this is nice. This is a very, very intimate group. Why I say that is because I come prepared for almost anything. I've got a little book there I've been referring to from time to time, which I've got all sorts of materials. If we were doing this with each of us speaking for 3 hours, I'd be ready to do it. And that's easy, really. That's easier than trying to keep it short. And so on the way down, knowing I wasn't going to have much more than 20 minutes, and that's what they told us, right, 20 minutes, in order to discipline myself, I took down some notes, which I'm going to have a great deal of trouble reading, and wrote them down as I was writing, which is probably just as bad as texting. But I wanted to explain a couple things before I get into this. I'm dressed a little differently from my colleagues tonight, and that was deliberate, because what has motivated me in preparing my remarks for tonight is I'll admit it right up front, it's anger. I'm an attorney, and as an attorney, I'm required to be a member of the New Hampshire Bar because of judicial fiat, because they claim authority to make us do that. It's one of the number of things they claim authority to do, which they really don't have, as Representative Itza has tried to explain to you. And so they're coming out against this amendment, claiming it threatens the separation of powers. And they did the same thing in 2004 when we had a similar amendment proposed. And I wanted to dress like just a regular person to kind of emphasize what you've been told by Representatives Mirsky and Itza, that we're not some kind of a bunch of yahoos that just sneaked in a guerrilla style and took over the government, invading the palace, and we're going to set up our a government by coup d'etat. We're the people's representatives. We stand for election every 2 years. We get paid $100 a year. I don't know if everybody knows that. This is a volunteer legislature, and it's almost the only one left. And the idea that all 400 of us in the House and the 24 in the Senate, and aided and abetted by the governor, whoever that may be, are going to somehow be able to work a total revolution and assume all the power, not only of the legislative branch, but of the judicial branch, is just so much nonsense. And the fact that this comes from the New Hampshire Bar Association in an editorial they put in the Bar News, which I received yesterday, is just so frustrating to me. These people, of whom I'm an unwilling member, they're a bunch of nimrods, to put it quite frankly. They don't understand the Constitution, and they're not alone, because the justices themselves don't understand it very well. We were taught as kids, Santa Claus brings toys on Christmas, Easter Bunny brings eggs on Easter, and the Supreme Court has final authority on the meaning of the Constitution that's binding and final on the legislative branch. Well, I'll tell you, at least one of those is false, and it's the third one, and you've seen why that is so. But we've become so conditioned by the claims repeatedly made over the years, not by our court at first, but by the federal court, of such power, dating from Marbury versus Madison, and never challenged effectively by the legislative branch, because so many people are just so clueless about the Constitution that it's just become accepted fact. And we read helplessly in the papers or hear on television about how the courts made this or that ruling, and that's it. That's the meaning of the Constitution, and that's not correct. I had, I'm looking at these notes here. The way my friends in the Bar Association would have you believe it, and as former Chief Justice Broderick put it when he and I were on the exchange on NPR, I guess it was a week ago, we're somehow able, all 424 of us, to work this revolution in our government to corrupt the whole process. And I have to put it to you, this little perspective here. The Supreme Court has 5 members, all right? We have 424. They have salaries, so they don't have to be distracted by any other pursuits in life. They make, I think their pay is $133,000 a year. That's not with benefits. They also have benefits. We get $100 a year. We don't get any benefits. We can pay for our own health insurance through the state system, but that's just like a regular family policy. I can't afford it, so I haven't bought into it. And of course, we don't have any pensions. Once we're out, we're out. They are a very homogeneous group. They are the elite lawyers, and they come from the usual schools around here, primarily Boston University or Boston College, whereas we come from all sorts of backgrounds. It's astonishing, as I've gotten to know various members, how diverse our backgrounds are, how diverse our experience, and it makes the process of legislating a very rich one, a very rewarding one, but also a very frustrating one, because we see the world so differently. I'm an attorney, Representative Mirsky is an architect, Representative Itz, as he told you, is an engineer, and Representative Ingbertson is an artist. He paints portraits. That reflects the legislature as a whole. It's just amazing, the backgrounds they have. But it makes it rather difficult to form a conspiracy when you have 400 people of such diverse backgrounds. And as opposed to the court, where you have 5 people who see life very much the same. They're like the elite of the elite. We go to law school, we think we're pretty smart people. We got good grades on the LSAT, and we managed to get through the hard way, by graduating, and we passed bars. And I've passed 2 of them. Aren't I special? By the way, I was thinking on the way, Abraham Lincoln never went to law school. I don't know if you know that, but we're a credential-crazed society, so that's very important. So I'm bragging here. I've got the credentials. So I'm a member of the elite. But the judges, though, they're the elite of the elite, and they see the world differently from just the mere elite like me. Because as smart as I think I am, I'm not so smart that I think I know how to live your lives better than you do. But there comes a point when you become so smart that you start becoming stupid again, and you really believe that you know better how other people should live. And that's a disease to which the courts in this country are prone, and that's why they make so many policy decisions these days and overrule the legislatures. And that's even after they dictate what the election laws should be. They don't think the election process is pure enough, so they're dictating how we shall hold elections. And yet, having done that, they are not willing to abide by the results of the process of the legislators that they want to get elected according to their rules. So that's what we're confronted with, a judiciary that is so sure of its intellectual superiority and so hostile, not just suspicious, but actually hostile to representative government. It's very disturbing. So now, let's go to the Constitution again. Article 72A, that's the one that Representative Itza referred to, that established the Supreme and Superior Courts as constitutional courts. And it reads, and I don't know the exact wording, but it says, the judicial power of the state, something like this, the judicial power of the state shall be in a Supreme Court and the Superior Courts. What is judicial power? Well, very simply, judicial power is nothing more than the right to, the authority to hear and decide cases. That's it. That's it. And that's why Alexander Hamilton in the Federalist number 78 said that in his opinion, the judicial branch is the least dangerous branch, because that's all it has. It just has judgment, and it has to depend upon the legislative branch for its funding to pay their salaries and to provide them with the facilities in which they do their hearing and their judging, and they depend upon the executive branch to carry out their decisions. But as things have developed over the years, the judges have come to believe that they have all sorts of additional powers. I think former Chief Justice Brock actually said an opinion, I didn't have time to find it, where he said the court has inherent power to do all things necessary to see to its survival. You know, it's like a Darwinian kind of thing. So they could assert any kind of authority they want to be able to carry out their function, and that's, unfortunately, that's just not how it is. But they've come to accept that so much that what we're trying to do here to get the legislature involved in what is essentially a legislative, it isn't just essentially a legislative function, it is a legislative function. Rulemaking is a legislative function. And yet, we trying to interpose ourselves in this again is somehow a threat to the judicial power. Okay. Judicial acts. What's a judicial act? Well, a judicial act is ruling on a case. A legislative act is setting rules for future to govern future cases. In other words, a judicial act is one where you are settling a dispute between parties to the court under the rules then in effect. A legislative act is setting rules to govern future disputes. Very, very simple, and that's the distinction that was laid down in a seminal case, Merrill versus Sherburne. In this case, it's often called the Marbury versus Madison of New Hampshire, but that's like so many claims of that sort. It's an exaggeration, and but that certainly fits in with the the Black's Law Dictionary definitions of the two things. So the judiciary has power over judicial acts, legislature over legislative acts, and somehow for us to propose to reimpose our power, even to the point of preeminence over what the court rules should be, threatens the separation of powers and the independence of the judiciary. I'm having trouble being coherent about this because it just boggles my mind that people would not recognize how foolish that is, and yet the former Chief Justice believes that. The former Governor Merrill believes that, and they've editorialized on it. Former Justice Nato, and so here we are. Now, I brought among all those papers, I brought up here to show you, which I have trouble doing, a list of chapters. These are chapters of the Revised Statutes Annotated, not just individual statutes, but whole chapters which contain many statutes. And these are RSA chapters that relate to court procedure. These are enactments we did. The legislature's been doing this for 2 centuries. But to hear them talking about it now, we're doing something entirely new. I can't read them, but I count 8 chapters towards the end. From chapter 506, wait a minute. A lawyer who can't read. From chapter, Title 52, Actions, Process, and Service of Process, goes from chapter 506, Prevention of Frauds and Perjuries, through chapter 513, Arrest and Bail. All rules laid down by legislation to govern court procedure. Title 53 is even more direct. The title of that chapter is Proceedings in Court, and it goes from chapter 514, Notice, Default, and Abatement, to RSA chapter 526, New Trials. Title 54, Executions, Levies, Bail, and the Relief of Poor Debtors. Execution means enforcement of judgments, doesn't mean hanging people. And that runs from chapter 527, Executions, through chapter 533, Relief of Poor Debtors. Title 58, Proceedings in Special Cases, running from chapter 534, Habeas Corpus, all the way through chapter 546B, Uniform Interstate Family Support Act. There's just all sorts of this stuff, and so I would just leave you with a couple of thoughts. One is, given the small number, the homogeneous nature, the salaries, the fact that they deliberate in secret, that characterizes the judicial branch, compared with the legislative branch, which which has 424 members. Everything we do is in public. We have public hearings on every bill. Our executive sessions in the committees are public sessions. We vote in public sessions in the full House. And then when you get a bill through the House, the whole process starts over again in the Senate. And then even then, the governor has to concur. You compare how we do our business compared with the courts, how the court does its business, and you have to ask yourself, if one branch is going to be conspiring to undermine the form of government we have, which is the one more likely to be in the process of doing that, the legislative or the judicial? And I'll stop there. Thanks very much.